Happy Monday and welcome back to another week. I'm Jake Wolfenden with Summit Safety Group, and we have some updated OSHA news to pass your way. This past week, both the House and the Senate overturned a final rule from OSHA that addresses employers' ongoing obligation to make and maintain accurate records of work-related injury and illness data. The House and the Senate passed a joint resolution disapproving the so-called Volks Rule, which OSHA issued in the final days of the Obama administration. The Volks Rule represents a legal battle between the Department of Labor and a small construction company named Volks Construction. This company had been cited by OSHA for not having accurate reporting on their OSHA 300 logs from a couple years back. What the courts found out in this case was that the manager who monitored these records had passed away and they simply fell through the cracks. There was no purposeful abuse of record keeping in this instance, and therefore the company felt that it was almost a bullying tactic by the government to cite them for records during this time frame, and frankly, a sad time for them and their teammates. Now, just some back history: employers have long been required to record and maintain work-related injury and illness data over a 5-year span. However, they could be cited for violations only within a 6-month time period. Those guidelines changed December 19th when OSHA published the Volks Rule, which allowed citations to be issued up to 5.5 years after violations allegedly occurred. Supporters of the rule say it would allow OSHA to enforce accurate injury and illness record keeping. However, critics claim it would create burdens for employers without providing any proof that worker safety would actually improve. Since this ruling was issued within the final 30 days of the Obama administration, the House and the Senate had the legal right to re-vote on it because anything pushed forward in the last 30 days of any administration can be overturned. Since the Republicans own the majority in both the House, Senate, and of course the White House, they took full advantage to overthrow this first and foremost. Please understand, although this does overturn one record-keeping law, it does not have anything to do with the new electronic record-keeping rules that are still in effect. In short, what it does mean is that OSHA can only look back at your records for the prior 6 months of any investigation that has begun at your employer or business. They can no longer cite for any errors that may have occurred in the previous 5 years or more. However, you are still required to keep these records for a minimum of 5 years for reference sake only. As always, if you have any questions at all, please reach out to us at info@summitsafetygroup.com or simply ask your Summit Safety Group consultant and they'll guide you in the right direction. Hey, I may not know you, but I do care about you. I'm Jake Wolfenden with Summit Safety Group, and I will see you next Monday. Have a great week.